Appeal stands dismissed.
Lordship, with regard to item number 1, the Amiga Security Council is A Begum is out of station, so I created Meta for protection.
Yes, she informed me in the morning that and
Where is
paper
she?
book is ready.
She is in Shipsagar.
Doing what?
His home is there, so he went there, and there's some incident in the home, so she could not come back in time.
On the prayer for adjournment made on behalf of Miss Arfina Begum, legal aid counsel for the appellant, and which is not objected to by Miss S. Jahan, additional PP. This is the matter for hearing.
Paper book is otherwise ready.
This is the matter for hearing. In usual course, as paper book is ready. Has the paper book been given to you?
Paper book, of course, I don't have it today. But
Has it been given to the parties?
Yes, Lordship, Amiga Security Council has got, Legal Aid Council has got the paper.
two in numbers are shown, so perhaps it was given to all the parties.
Yes.
Yes,
Okay.
yes.
May I take your response? With consent with the other side, my lawyer.
Huh?
I beg to mention item number 3, my lord.
Item number 3.
See, my lord. One at time feeling fever, cold and headache, when I could not prepare, my lord. And after 10 days or 2 weeks,
Okay, right. Mr.
take care. sir.
A.K. Hussain, learned counsel for the appellant, prays that the matter may be adjourned as he is not feeling well. As the same is not objected to by the additional PP, this is the matter after
2 weeks.
2 weeks.
May I play a role?
Yes,
Lordship, I beg to mention for listing Lordship about 24/8/7 Lordship. Already.
Please, your lordship, I beg to mention for listing a criminal appeal on 24th.
May I please your Lordship, Lordship, this is an statutory appeal Lordship. The
302,
appellant
149.
Convicted Lordship under section 147, 148, 149, 302 and 201 Lordship.
convicted under what section?
302, 149
Okay, right.
and 201 also.
So we should notice that.
Lordship, issue notice. LCR may be called for Lordship.
Heard, Mr.
Ayu Chaudhary Lordship.
Ayu Chaudhary, learned counsel for the appellants, who submits that the judgment dated
28/6/23.
28,
6/23.
28/6/22 passed by the court of the
Additional sessions judge.
additional section Judge Bilasi Para, Dubri, in sessions case number 168 of 2012, by which the appellant has been convicted and sentenced under section 302 IPC as 302/149 IPC. Should be set aside.
As well as 201.
201.
302/149 and 201 IPC should be set aside. Admit the appeal, call for the LCR. Ms. S. Jahan accepts notice on behalf of the respondent number
1.
1. Who is 2?
Informant Lordship.
Not required.
Not required.
This is the matter after 4 weeks. Then in the IA 389,
Lordship 389.
Miss in the IA, right, Miss S. Jahan, additional PP is granted 4 weeks time to file written objection.
There were 10 number of convicts, 3 are before your lordship, perhaps
Yeah.
others have also filed.
Other not yet filed.
Acha.
List the matter after 4 weeks.
Lordship.
Okay.
In this matter, our prayer for preparation of the paper book was allowed. We require some more time to submit the paper book for verification of the department concerned section.
Then
2 weeks' time may be granted to us.
what about the IA?
It's already disposed of. There is no
That- that-
interim bail. No,
Show
no,
us
there
the
is,
IA.
no, earlier that was rejected.
That was vacated.
There is no. pending
Initially,
IA.
there was an interim order of bail that was
That is
vacated. and
rejected.
again,
No, but why is it
this-
still pending? There is one 320. 320 here.
But then
It
there is
says-
an order in 320, I think.
In 320, it says that direct suspension of the sentence for a further period of 1 month with effect from today. So this order was on 25/4/2023
Oh, there,
and it ended in May. So he should go back to jail. Has he gone back to jail?
yes, that has been rejected.
Rejected?
Yes, that has been closed. If your lordship peruses the order passed in the appeal.
Yeah.
No, they surrendered there inside. This
Yes.
is what my information is.
That is why on 25th May, no? 25th May, when the matter came up, that was,
Oh, so we'll have to dispose of this.
yes,
It was
there was
simply
no
like,
order probably
Yes,
passed in
ah.
the, yes.
Okay, right. In the main appeal, you write. Miss D. Borgain, learned counsel for the appellant, prays for a further 2 weeks' time to prepare the paper book, which is to be verified by the registry. Miss S. Jahan, additional PP appears for the state. Prayer of the counsel for the appellant is allowed. List the matter after 2 weeks. Then in the IA, you write. Miss D. Borgain, learned counsel for the applicant, and Miss S. Jahan, additional PP submit that in the main appeal, the order dated 25/5/2023 reflects that the temporary suspension of sentence for a period of 1 month, which was allowed by order dated 25/4/2023 in the present application, had expired on 25/5/2023. So the applicant/appellant was therefore directed to surrender before the Superintendent of District Jail, Martin Sukhya. Next, Miss S. Jahan, additional PP submits that as per her information, the applicant appellant has surrendered and is in jail. Next. In view of the submission made by the counsels for the parties, the present IA has become infructuous. The IA is accordingly closed.
Not.
As disposed of. In terms of the order dated 25/5/2023, passed in criminal appeal 208/2022.
Deeply obliged.
5, it's an estate appeal against acquittal. This is a POXO case. Now here what happened, the leave application, lordship has issued notice and that had gone, but then it could not be served through the normal registered post. So on the next occasion, lordship ordered that it should be done through the OC. And there is a mistake done by our office. They had not taken it through the OC. They had again taken the steps through normal procedure. So with lordship will give me 3 days time, I'll take it through the OC. There is an office note.
Okay,
that
you
took
give
it-
me the other, the other IA, is it,
This is condemnation.
give me the 276 also. We'll issue notice on both.
Yes, Lordship. There the delay is
Okay, in this,
69 days.
in this 12 of 2023, IA 12, you just write Miss S. Jahan, learned counsel for the applicant, submits that. Notice was to be served through the officer in charge of the concerned police station.
Hmm.
Full stop. However, the applicant had taken steps through registered post AD and not through the officer in charge, as had been directed in the order dated 12/5/2023. She accordingly prays for time to cause service
Hmm.
of notice on the sole respondent in terms of the order dated 12/5/2023. Prayers allowed. List the matter after
After 1 week or so,
2 weeks.
2 weeks.
List the after. Then in the other IA 276,
276.
right? Miss El Jahan, learned additional PP submits that there's the delay of 68 days in preparing the appeal against the impugned judgment and order dated 14/10/2022, passed by the learned additional sessions judge,
Come special. judge.
Special Judge Morigaon,
Morigaon.
in POCSO case number 24/2021. Issue notice, returnable in 2 weeks. The applicant is permitted to cause service of notice on the sole respondent to the officer in charge of the Morigaon police station within 2 weeks.
Gotcha.
List the matter after 2 weeks.
Gotcha. Six, Miss Meghali Burman had some personal difficulty. She called me in the morning. She had to take her mother to the hospital.
Okay,
So otherwise, notice is served.
paper book has to be made.
It's a POCSO matter, notice is served.
Service complete, sir.
Huh? Yes, that's right. Office note indicates that notice has been received by the respondent number 2. And the AD card is also in the record. As LCR has arrived, a registry to make paper book. List the matter after 4 weeks.
Gotcha. Seven, I filed my objection, must be on record.
My lord, I'm appearing on behalf of Mr. Zedas, who is a legal aid counsel. He is not well today.
Why?
He's suffering from some illness. Since LCR has been received, your lordship may drag the
Okay, right.
paper book.
In the appeal, you write. As LCR has arrived, registry to prepare the paper book, list the matter after 4 weeks. Then in the
I have filed
you're
my
right.
objection, it seems.
Miss S. Jahan, no, right, yes, Miss S. Jahan, additional PP submits that written objection has been filed. However, adjournment prayer has been made on behalf of Mr. J. Das on the ground that he is not well. List the matter after 4 weeks.
All right. I'm
Item 8, right. As LCR has arrived, registry to make the paper book and list the matter after 4 weeks. Okay.
I think the IA has come up for the first time.
No, here one report was called let's say, regarding juvenility law of the appeal
Oh.
activity
On the basis of what?
on the basis of its LP school certificate.
What?
LP school certificate.
Transfer
So,
certificate.
Yes, Lordship.
Transfer
After
certificate.
completion of passing out.
Now there is a judgment of the Supreme Court.
Lordship.
They have read
Yes, Lordship. I have. But this is the.
school transfer certificate cannot be relied upon to determine
Ah.
the age under the Juvenile Justice Act.
I've not gone through the judgment. Otherwise also, according to the rules, it is not applicable. I mean, there's.
No, but then it was being done. Then the orders had been passed.
But I think for getting a report, prima facie lordship has to satisfy that he is minor. So perhaps for calling a report, it will not be.
No, but calling a report on the basis of the school transfer certificate. You see, when the school transfer certificate itself
Hmm.
cannot be relied upon to determine the age,
Huh.
where is the question of calling for a report on the school transfer certificate?
That can be a.
You know, it's an exercise in futility.
Hmm.
In that case, also the other judgment is also there of honorable effect for Ashwini Kumar section. I have to see the bench composition, Lordship. Ashwini Kumar section says, Lordship, if the school first attended issued any certificate and on the basis of that attendance register is produced by the headmaster, then it is acceptable to determine the age. So I have to see the composition and all those things. Also, the future next week I will.
Otherwise, Act doesn't provide for school leaving certificate.
That's what.
But as far as calling for a report, lordship is correct. If
Yeah.
that is not applicable here, why will it be applicable here?
Yes.
But I think there's a Supreme Court judgment long back, prima facie lordship, if lordship is satisfied is minor, it will call for a report. Now on what basis? of
No, but
course?
then, prima facie, the High Court is satisfied. There's no question of High Court being satisfied when Supreme Court has laid down the law.
Yes, yes. This new judgment I've not seen.
I have to see, Lordship, whether in that case headmaster appeared or attendance register were produced or not. That I have to see.
Okay, all right. Mr. A. Ahmed appears for the applicant, while Ms. S. Jahan, additional PP, appears for the state. The counsel for the parties submit that in terms of the order dated 10/5/2023, the special judge Darang had been directed to call an inquiry and submit a report with regard to the age of the accused slash applicant on the date of the occurrence of the crime in view of the transfer certificate. Now, in pursuance to the transfer certificate dated 12/10/2019, issued by the headmaster, Pub Bola Bari LP School. In the last order, it is there, huh? In the apex court, in the case of P. Yuva Prakash,
Yuva Prakash.
yes, versus state, represented by the inspector of police, criminal appeal 1898/2023, has held that a school transfer certificate cannot be relied upon to determine the age under the Juvenile Justice Act. So just check up.
Yes.
Whether that age determination was done only on the basis of the certificate or with the register that I will.
Just check. I just read somewhere. Huh?
Lordship. I have seen.
As the report has not been submitted till date, list the matter
Report
after 2 weeks.
2 weeks.
First up, the counsels for the party shall also make submissions with regard to whether the report can be, whether the calling for the report would be an exercise in futility, keeping in view the above decision of the Supreme Court. Leaves the matter up to police.
All right.
It's UVA, Lordship, Yuva Prakash.
Yuva Prakash. YUVA.
YUVA, acha.
It's one name.
Honey, no, I'm trying to find out in Manupatra. Pale. 2 days ago.
2 days ago. Today must be. I read it, I think yesterday or somewhere.
Yes, I got it. It's reported in Manupatra.
Ravindra Bhatt, I think.
Reported in
Ravindra
Manupatra. With two judges bench.
Two judges.
Justice Ravindra Bhatt and Arvind Kumar. But we'll see. It's a long judgment. Not, yes, not very long. It's only 22 paragraphs. I'll go through it.
Yes,
May please, Lordship. But notice of issue to the Lordship informant, probably Lordship it does.
Acha, by the way, wait a minute. What about the IA?
I thought it's for 389. He didn't say anything.
Just call him. He's out. Have you filed a written objection?
No, Lordship, this is, we have not filed.
Okay, then
but-
no need to call him. Then in the IA, you write.
I is for, I think for juvenile purpose, so I'll have to check why is that I for? No.
Okay, what is the IA for? 389? Is it 389? 389.
Then I'll file.
Okay, Mrs. Jahan. Additional PP is granted 2 weeks time to file WO. In the IA, okay. Yes, what is to be done?
Rajat Prabhu
LCR has
have
not
filed.
received.
Huh?
LCR has probably not received.
Not received. Then there is no AD from R2 also. It is a POCSO case.
Lordship.
Then I'll instruct the IO to serve the
Okay.
notice.
Okay, right. Counsels for the parties are present. Office note indicates that no AD card has been received from the respondent number 2. The Ms. S. Jahan, additional PP, submits that she will instruct the officer in charge of the concerned police station to serve notice upon the respondent number 2. As LCR has not arrived, a reminder be sent for the LCR. This is the matter after 4 weeks or 4 weeks. 3 weeks.
Lordship, I is also there.
3 weeks. 3 weeks. Have you filed a written objection?
No, Lordship.
Miss, in the IA, right? Ms. L. Jahan is granted 3 weeks time to file written objection to the application under section 389
Lordship.
CRPC.
No. Obliged.
Happy to Lordship. My lord, I've been convicted under section 16(1)(a) UAP Act
16(1)(a)
1A of the UAP Act
UAP Act.
and have been punished for rigorous imprisonment for life under that section. And under section 20 UAP Act for 7 years.
Yes.
Under section 302 IPC for life. 307 for 8 years,
307 for
8 years. And 386 for 5 years. All the sentences were to run concurrently, my lord. I have already undergone 8 years
UAP for life,
16
16 for life, 20 for 7, 302 for life, 307 for 8, 386 for 5 years.
There are only two witnesses who have said that they have seen me committing the offense.
2 witnesses,
PW2 and PW3,
2 eyewitnesses even.
two I.
So isn't that enough?
According to
PW,
my lord,
PW,
2 and 3.
according to you, what, they should be 5.
No, I'm
Four.
saying they could not have stated
Seen you.
same. So if I may please PW2.
Huh?
PW2 if I may please.
Page.
Page 13, my lord.
Where? Oh, wait, why don't we go to PW1?
PW1, my lord.
Yes. Who is the
Let me place the
informant?
FIR first, man. Please PW2 move. Informant is Syed Ali. PW2.
Huh?
PW2
PW2 is the informant.
is the informant. The
Okay.
FIR is at page 4, my lord. If I may place the FIR first.
Yeah.
Humble submission is that around 11:30 PM,
FIR dated
Dated
3/5/2014.
3rd of May 2014,
Yeah.
that around 11:30 PM on 1/5/2014, Thursday, a group of unidentified miscreants, 20 to 25 persons, belonging to Boro community armed with deadly weapons, entered my house and houses of my co-villagers, Bachu Sheikh and Farid Ali, by breaking open the doors and started firing indiscriminately all of a sudden. As a result, my mother, Sayatan Deva, my wife so-and-so, my daughter so-and-so, and Bachu Sheikh, Mustafa so-and-so, sustained gunshot wounds while they were sleeping and died on the spot. Farid Ali, Manohar so-and-so, Tajur Haq sustained grievous wounds. Maharban Bibi died yesterday, that is 2/5/2014, when she was taken to Dhubri Hospital, and other 2 injured persons are undergoing treatment at GMCH. Therefore, it is prayed that necessary action may be taken.
Yes.
In the incident, 7% died.
7% died.
7% died. And 2% were injured. However, the charge was framed at least 7, madam.
How many persons injured?
2%, madam. Farid Ali, Taznur Haq,
Okay, go to PW1.
PW1. He is Farid Ali, madam. He is one of the victims who sustained injury, madam. Farid Ali, he says, today I have appeared before the court on receipt of summons from the court. On 1/5/2014, I was at my residence at village Balapara, part 1. Before that, I was at Kolkata doing business. I came back for casting vote. On the day, I was sleeping at my house along with my wife, Jalina Bibi, daughter so-and-so, son so-and-so. We had food around 9:30 PM, and thereafter we went to sleep. We had 2 beds in one room, where I and my daughter, Farida Khatun, and in one bed, and another bed, my wife, Jalina Bibi, and son, Muhammad Jaimul Ali. My house is built of half brick wall. At around 11:30 p.m., I heard a big sound on the door. And at that moment, my wife, who also woke up, told me to go underneath the bed. There was another sound on the door, and the door got opened. And thereafter, there was indiscriminate firing. In the firing, I was hit by a bullet on my waist. In the said firing, my wife Jalina Bibi and daughter Farida Khatun sustained bullet injuries and they died. There were 4 to 5 miscreants who fired at my family. After firing, and when they were sure that they have killed the persons inside, they went out calling them as Foidu Foidu.
Where is Foidu Foidu?
It's in Boro language, most probably.
Look at that.
In the firing, my son named Jaimul Ali survived. I then walked where there were village people and were gathering, and I handed over my son to one of the villagers. From there, I was carried by a thela to Sapatgram hospital. There I was given some first aid, and there I was taken to Dhubri Civil Hospital. In the hospital, I was given stitches and medicines, and from there, I was taken to Guwahati Medical College Hospital, GMCH. I was at GMCH for 15 to 20 days undergoing treatment. I came to know that the above incident was done by NDFB miscreants. In cross, he says, I cannot speak in Boro language, but I can understand a little bit Boro language if it's spoken before me. My feeling is that the incident was done by NDFB people.
Look, I want to be, let us be very clear.
Right.
There are around 31 witnesses, I think, more than 30 witnesses. Now, if we're going to go through the entire list reading, we're going to take the whole day. It's quite thick. Now, how much time are you going to take? If you go at that rate, then you'll never finish today. So when are you finishing? Oh, you cannot go through each and every page reading. You'll have to select your witnesses and select the passages. Well, if we go through like that, I mean, never going to end.
In that case, Your Lordship may give me some time. I can prepare a very short, I can finish it in 1 hour. If I can prepare it for 2-3 days, I can finish it in 1 hour. I can identify who are the eyewitnesses. There is an extortion team, who are the witnesses, what they have said, whether they are reliable or not. I can make it very brief. In 1 hour, I can complete that.
It doesn't have to be 1 hour, I mean, but it should
If
be
I am given
reasonable
2-3
time.
days time, my lord, I can do that.
Huh?
2-3 days time if I can give it,
Because the way you're going,
my lord.
I mean, it's the witness, it's this.
My lord, it's a hit.
We're
There are
never going to
exhibits
end.
also.
Yes, Mr. Chaudhary, what do you say? Because-
Subject to what he says, I will be referring to around 6 witnesses.
You don't have-
Rest,
doesn't-
I do not think would be material for your lordship's consideration.
Correct, others by the rate we're going, he's never going to finish today also. And you
But,
see, the others, we can read it on our own.
My lord.
Only the relevant witnesses which are relevant to you and for deciding the
this
case.
My lord.
And which are the case, who are the witnesses who are basically hearsay evidence, giving hearsay evidence, and who are relevant, that's all. So you have not prepared or what?
My lord, I didn't come to the court yesterday also. My wife was not well. So if I may be given 2-3 days time, I can prepare that. There are 2 other cases that's small. I can do it today only.
It's, you see, this doesn't really
But,
bother
to
us.
prepare it in
This
that manner, my lord.
only problem is that if you confine yourself
Certainly.
to the relevant portions of the records.
In that case, lordship, I can also make a small brief note and because I will not be
Brief-
going to all the. reports.
Brief note not required, but at least, I mean, if you make it, that's a different thing. But at least, if you can confine yourself to.
Certainly.
Yes,
Specific.
yes, yes. Otherwise, we'll go through the entire thing that we can all go through at our own pace and at home.
Right.
That we will do. But if we keep on reading, we're going to win the court side. Right. on the prayer made by the appellant's counsel for adjournment to enable him to make better preparation. List the matter after a week. Okay. But then if you have got two eyewitnesses against you, then what remains?
Indiscriminate firing, they said we kept ourselves hiding from the hiding, and it was dark, 11:30 in the night.
There
I think so.
must have been some light.
There was.
It was one side, light was on the other room.
So that's enough.
I place everything. God bless you.
Yes, what is your case, madam?
The POXO matter. POXO lordship. POXO case here, what had happened is the accused is alleged to have taken the minor girl while she was playing with her friends. And then her body was found in the morning with a biscuit packet. In fact, the other boy said that the accused had given a biscuit packet and took her. And with biscuits on her face, her body was found lying in the veranda of a dilapidated house. Only the boy's evidence are there, but then there is contradiction.
Yes,
So Lordship, may I read the Ajahar?
Huh?
From the Ajahar, may I read the Ajahar?
Yes,
Lordship,
yes,
first? Lordship. Page 4, Lordship, Ajahar was lodged on the very next day. Lodged by PW1, father of the deceased girl, Lordship. Girl is 6 years old.
girl is 6 years old.
Girl was 6 years old at the time of incident. And her mother had expired long back, Lordship. Only she and her father is there. And this Ajahar was lodged on the 2nd day of January. Incident took place on 1st day of January 2015, Lordship. So page 4 of the paper book, Lordship. Humble submission is that from around 5 p.m. on 1/1/2015 Thursday, my 6-year-old daughter went missing suddenly while she was watching the sports event organized by the local people on the occasion of New Year at number 1 Bordubi Gaon, Gajal Bosti. I went in search of her at night with the help of local people, but could not find her. But at around 10 a.m. today, when Sri Biki Tati, son of co-villager Bijoy Tati, informed that my daughter Punam Tati was lying on the floor of the rear veranda of an unoccupied rented house, I went there with the local people and found the dead body of my daughter there. As Sri Biki Tati so-and-so has said that he had seen my daughter with Sri Sunil Murari, so-and-so of our village in the evening of 1/1/2015, I suspect that Sunil Murari killed my daughter after committing rape on her. So this is the Ajahar, Lordship. So as per this, Lordship, on suspicion from the evidence of Biki Tati, and there is another also one PW3, Lordship. Their evidence is that when both of them were playing, the accused took her with him, Lordship. Lordship, PW1, page 8. Page 8. PW1 is the informant. I know the accused. The deceased Punam Tati was my daughter. At the time of occurrence, the age of my daughter was 6 years. My wife had expired long years back. On the day of occurrence in the afternoon, after coming back home from my walk, I found my daughter missing. I inquired her at the nearby possible places. On the day of occurrence, as it was 1st day of January, parties were going on at nearby places. Failing to find out my daughter, I asked Biki, son of my younger brother, about the missing of my daughter, and Vicky told me that he had seen the accused taking my daughter by giving her a packet of biscuit to somewhere. On the said night, I could not find my daughter. On the next day at about 11 a.m., while I was trying to find out my daughter at the nearby places, I saw a gathering near a vacant kacha house situated near my house. Upon approaching, the people who were gathering near the said house told me that a dead body of a child was lying inside the said vacant house. Accordingly, I went there and found my daughter lying dead, and her face was tied with cloth and piece of biscuit was stuck on her face. The neighboring people informed the matter to police, and accordingly, police arrived at the spot. During investigation, police brought sniffer dog, and the dog led the police party to the house of the accused, and then police arrested the accused. During interrogation, the accused confessed before police that he had killed my daughter after raping her. On the same day, I got an Ezahar written by one of my neighbors, Sri Prakash Kumar Sahu, and lodged the same at the police station. I put my signature in the Ezahar. Exhibit 1 is the Ezahar, wherein Exhibit 1 is my signature. Police conducted inquest over the dead body of my daughter in my presence. Exhibit 2 is the inquest report, wherein Exhibit 2.1 is my signature. Thereafter, police sent the dead body for post-mortem examination. Police recorded my statement. On the day of occurrence, my daughter was alone in the house. I used to stay with my daughter in my house. My wife had expired long years back. Cross. It is not a fact that I did not state before police that failing to find out my daughter, I asked Vicky, son of my younger brother, about the missing of my daughter. And Vicky told me that he had seen the accused taking my daughter by giving her a packet of biscuit to somewhere. I did not see the occurrence. It is not a fact that I did not state before police that during interrogation, the accused confessed before police that he had killed my daughter after raping her. It is not a fact that I did not state before police that during investigation, police brought sniffer dog, and the dog led the police party to the house of the accused, and then police arrested the accused. Out of suspicion, I lodged the Ezahar against the accused, as he had confessed before me and police that he had killed my daughter after raping her. It is not a fact that the accused did not rape my daughter and kill her. Here, Lordship, I want to submit, Lordship, that as per his evidence, he came to know in the same very day after coming back to home, Lordship, that from this fifth line, Lordship, that sixth line, Lordship, that Vicky told that his daughter was taken by the accused, Lordship, but he had not taken any steps to even go to inquire on that night about his daughter, or even ask the accused about the present where his daughter is. He, on the very next day only, he was again searching for his daughter. And then at about 11 a.m., he came to, he saw some gathering, and then he found the dead body of his daughter, Lordship, where he came to know that the accused had taken his daughter in the previous night, and he came to know about the same on the very previous night, Lordship. And these facts were never stated before the police, although it is also in the evidence of all the PWs that sniffer dog had went to the house of the accused, but from the evidence of IO, Lordship, there is no mention of taking of sniffer dog, or sniffer dog went to the house of the accused, Lordship. If his name was already mentioned, then why he should have been lost the Ezahar on suspicion? He straightly, Lordship. Other evidences, Lordship, PW2. First, some questions were asked to see whether he is capable, because he is 10 years old, Lordship, that the evidence, Lordship. I know the accused person, he resides near our house. I know that this is Punam Tati, who was the daughter of my Borta uncle. The victim was my sister. On the day of occurrence, I, as well as Suraj, was playing in the afternoon in our house. The victim was also near us. Then the accused came to us and took the victim with him by asking her to play at his house. The victim did not come to her house on that day. When the victim did not come home on the said night, on the next day, all the person, including her father, were searching her. I also searched her. On the next day, I, along with Suraj, found the deceased lying dead in a vacant house situated near our house. Thereafter, we informed the matter to our elder. Police was informed. Police brought sniffer dog, and the dog led the police party to the house of the accused, and thereafter, police arrested the accused regarding the death of the deceased. Police recorded my statement. Cross. It is not a fact that I had not stated anything before police, whatever I have stated in the court today. I do not know as to how the deceased died. PW3. He was with PW2. I know the accused person. I knew the deceased Poonam Tati. On the day of occurrence, I along with Vicky and Poonam were playing near our house. At that time, accused came with marigold biscuit in his hand and asked Poonam to go to his house for having food. Accordingly, Poonam went with the accused. I saw the deceased going with the accused somewhere. On the said day, the victim did not come back to her home. On the day of occurrence, the father of the victim had gone out for his walk. On the next day morning, I along with Vicky searched Poonam and ultimately found her in the veranda of a deserted house. She was lying dead in the veranda of the said house. Thereafter, we went to the mother of Vicky and father of the deceased and informed the matter to them. Police came to the place of occurrence. Police also brought dog squad with them. The police apprehended the accused and took him to the police station. Police recorded my statement. Cross. It is not a fact that I did not state before police whatever I have stated in the court today. I do not know as to how the deceased died. PW4 Lordship, he is one of the neighbor Lordship. I know the accused as well as the complainant. On 2/1/15 at about 1:30 p.m. when I came to my house from my shop, I saw a gathering in front of my house. Police was also present there. I came to know that in the veranda of a dilapidated house situated nearby, the dead body of the deceased was found, and I identified the body to be the daughter of the complainant. Police brought sniffer dog to the place of occurrence and the said dog went to the house of the accused, but at the time the accused was not in his house. I heard from Vicky Tati and Suros Tati that the accused person took the victim with him by giving her biscuit from the place where she was playing. Police took the dead body for post-mortem examination. Police asked my name and address. Police recorded my statement. Cross. I know the accused as he resides at a distance of about 100 gauge from my house. Police did not ask me anything about the occurrence. Police took my signature on some papers only. I did not state anything before police. That is why I do not know if police had written something which I had not stated before them after obtaining my signature on the paper. Whatever I have stated in my examination in chief, I had not stated the same before the police because police did not ask me anything about it. It is incorrect that police recorded my statement as stated by me in my examination in chief. I do not know as to how the deceased died and only saw the dead body of the deceased. PW5. I know the accused as well as the complainant. On 1/1/15 in the afternoon, the daughter of the complainant was missing from his house and he was searching his daughter at every possible places. On the next day, in the morning time, the dead body of the deceased was found at a dilapidated house situated near the house of the complainant. Vicky Tati and his friend found the dead body of the deceased in the said house. Knowing about the occurrence, the parents and villagers rushed to the spot. Police also arrived there. Police brought sniffer dog and the said dog went to the house of the accused. Thereafter, police apprehended the accused. Police conducted inquest over the dead body of the deceased. Cross. It is not a fact that whatever I have stated in my examination in chief, I did not state the same before police. I do not know as to how the alleged incident took place. I am an illiterate person. At the time of putting my signature, police did not read over the contents of the same before me. As asked by police, I put my signature on the paper. I know the accused being the resident of the same locality. PW6. I do not know the accused person. I also do not know the complainant. The alleged incident took place about 1 year back. When people gathered at the place of occurrence, I also went there to see as to what had happened. Police already arrived there prior to my arrival. I came to know from the gathering that a dead body of a minor girl was recovered. Police took my name and address. I do not know anything as to how the alleged incident took place. PW7. I know the accused. I also know the deceased Poonam Tati, who was aged about 6 years. Occurrence took place on 1st January 2016. On 2, it may be 2000, it might be 2015 lordship. On 2/1/15, village people from number 1 Bordubi Gaon Gajal Bosti informed me over telephone that a dead body of a minor child was found lying in an abandoned house in their village. Thereafter, I myself and Boruk Patra came to the place of occurrence. I saw several people gather in the said area. I also saw the dead body of minor girl was lying on the floor and the mouth of the dead body was wrapped with cloth. At the village people gathered there, I came to know that two minor girls told the parents of deceased that they saw accused taking the deceased with him by giving her biscuits. I also came to know that the name of deceased was Punam Tati. After a while, police arrived in the place of occurrence. Police also brought sniffer dog and the sniffer dog went to the house of the accused person that police apprehended the accused person. Sunil Murari stated before us that he took Punam Tati to the abandoned house of Rajamoni Hatiborua and committed rape on her. While the victim Punam Tati shouted, he also put cloth in her mouth and after committing rape, he killed Punam Tati by strangulating her. When the accused confessed before us, Assis Ghasi, Varun Patra and several villagers were present besides the police. Police took the dead body for post-mortem examination and also took accused person to the police station. Police seized wearing apparel of victim guard and accused person. Exhibit 3 is the extrajudicial confession statement of Sunil Murari alias Bitna before the executive magistrate so-and-so. And exhibit 3.1 is my signature in the said extrajudicial statement. And as I was present at the time when the executive magistrate so-and-so was recording the confession statement of Sunil Murari. Cross. I do not know how the occurrence took place. It is not a fact that I have not stated before police what I have deposed in the court today. I put my signature in exhibit 2 in the police station. In fact, Lordship, this what they are mentioning about extrajudicial confession, Lordship, this is before police, Lordship, and this was recorded by the IO himself, Lordship. But this the before magistrate, no confession statement was recorded, Lordship. PW 8.
Yes.
I know the accused person.
2 minutes. Yes.
Lordship, PW 8, Lordship. I know the accused person. He is the co-villager. I know the informant Sandan Tati. He is my far relative. I also know that this is Punam Tati. On 1st January 2015 at around 10:30 a.m., I was in the Duliajan town. Then my aunt Urmila Tati informed me over telephone that Punam Tati was lying dead in an abandoned house near the house of my aunt. I immediately came to the place of occurrence and saw villagers were also gathered at the place of occurrence and saw the dead body was lying dead down in the veranda of the abandoned house. After my arrival, police also arrived in the place of occurrence. Police brought sniffer dog along with them. Sniffer dog directly went from the place of occurrence to the house of the accused. Police apprehended the accused. Then we asked the accused that how he killed Punam Tati. Then he confessed that on the previous day evening at around 5:30 p.m., accused met Punam on the road and he told that he would take her to the site of the accused house and give her biscuit. Police was also present and accused confessed the same. At the time of making confession statement, I, Prakash Kumar Sahu and Borun Patar was also present. Police took him to the police station and next day police also brought him to the place of occurrence where he saw the place where he committed the crime. Then the accused made extrajudicial confession statement before the executive magistrate so-and-so. And at the time of making said statement, I was present and I put my signature in the said extrajudicial confession statement. Police recorded our statement. Cross. I have not seen the occurrence. I put my signature in exhibit 3 at police station. Exhibit 3 was written by one police and I do not know his name. It is not a fact that I have not stated before police what I have stated today in the court. PW 9, Borun Patra. I know the accused person since the time of occurrence of the case. I know the informant Chandan Tati. I know that this is Punam Tati. The incident occurred on 1st January 2015. On the day of occurrence at around 10:45 a.m., I received a phone call from the village of the deceased, and the phone call was from Gaubura of Gajal Basti, and he told me that a dead body, a small girl aged about 5 and 6 years, was lying in an abandoned house belonging to some Hatibora.
That is required. Then no examination of files.
Is there any clear contradiction in the statements made by the witnesses? With regard to the 161 and evidence, is there any contradiction? No.
Let us see.
If it is not there, that is what my doctor is saying. If it is not there, Is it required to have the IO examined?
My lord.
Without the prosecution, can the case be proven?
It was argued by in the trial court, my lord. The defense counsel argued that there are severe contradictions in the evidence of PW 1 and 4. Since the investigation officer could not be examined, these contradictions could not be proved.
Rest,
Paragraph 30 of the judgment, interim judgment, my lord.
read paragraph 30,
30, page 36.
page 36.
My lord.
Paragraph 13,
30.
1330. The severe contradictions in the could not be, this could not be proved. Let us see the evidence of PW 1 and 4.
PW. Page 7, my lord.
Let us go straight away to the cross examination.
PW one cross examination, last but second paragraph, page 8.
Yeah.
It is a fact that I had not stated before the police that Ragda to do inform me about the injuries caused to Hopna to do by the so and so. But your lordship, there are two child witnesses in this instant case, PW 5 and 6, my lord. Their competence had been tested by the learned court below.
Who is 4?
4 is my lord,
Maybe a neighbor, my lord.
yes.
He's nothing.
He's
This one
nothing.
is
And
nothing.
in processes, when I met Hopna, who had died, he could not speak.
Why die?
Why was I was not examined?
Paragraph 7, my lord. Of the judgment, interim judgment,
Judgment.
page 26. The attendance of Bhaskar Jyoti Nath, the investigating officer, could not be secured despite issuance of coercive processes. He refused to come.
Is the non-exhibit of the FIR and the other document, is it fatal to the prosecution's case? Huh?
Lordship, actually, the case initiated with the lodging of the FIR, criminal case, my lord. And your lordship, preliminary investigation is done by the IO concerned, your lordship. So whatever the witnesses stated before him, it has to be, lordship has to be contradicted, it has to be contradicted, your lordship.
No. That is not the issue. You see, because 161 statements are not exhibited. The question is whether the FIR, what happens if you do not exhibit an FIR?
The
What
detail you
happens
have to
if-
look into, your lordship, because the initiation of a criminal case.
Is by through an FIR, no doubt.
FIR,
But suppose it is initiated, charge sheet filed, trial done. But what happens if you do not exhibit a FIR? Is it fatal? Any judgment?
I have to. Have you brought?
Not fatal, but the case has been remanded. The
Huh?
other case.
There is a similar matter. There are sure.
Fine. This is of our High Court manual.
RV Bishpa.
I place paragraph 1, 13, 20, 21,
One,
and 24.
1, 13,
Lordship, before my learned friend proceeds further, I will also go into the legal aspect with a non-examination, non-exhibiting FIR,
The
non,
FIR, the medical.
yes, my lord. So,
Report.
yes, matter will fix on Tuesday, coming Tuesday or
Let me
Monday,
that.
your lordship,
But let
Monday.
us just go through this one.
My,
113,
113. 20, 22 and 24, madam.
20, 22 and
24. The present criminal reference has been preferred under Rule 9 of the rule so and so. In connection with the judgment and order passed by the just dated 30/8/2006, passed by the district magistrate so and so. In reference to the offence under section 302, 384 and 34 of the IPC, read with 25 IB of the Arms Act, whereby the murder of KKNR, two accused persons, namely so and so, have been found guilty under section 302 and so of IPC. And the accused Monir Ali has been convicted and sentenced for life imprisonment and pay a fine of 10,000 in default for payment of so and so. I'll place that paragraph 13, madam. Mr. C. Lal Ramalja, learned amicus curiae for the respondents, has submitted that the impugn order dated 38/2003, passed by the learned district magistrate so and so district, suffers from major legal infirmities. According to him, the FIR, search list, seizure list, inquest report, medical report, postmortem report, etc., have not been exhibited and considered during the trial as required under law. Next, I'll place paragraph 20, my lord. The impugn order dated 38/2003 has come before this court by way of reference. On perusal of the case records, we find that the documents, namely FIR, search list, seizure list, inquest report, medical report, and these have not been produced.
Doctor was examined.
doctor was examined, my lord.
Doctor was examined, but he did not exhibit the postmortem report. It is difficult for the trial judge to have a satisfaction without going by the documents. That whatever the witnesses are saying are true.
Lordship on Monday then,
next.
Monday. Monday. If your lordship satisfied there is irregularity, your lordship may send it back.
Yes. Okay, right. Heard, Mr.
B. Prasad.
B. Prasad, learned counsel for the appellant, who at the outset submits that the matter should be remanded back to the learned trial court, inasmuch as no document had been exhibited before the learned trial court, and neither was the IO examined. Even though examination of the IO is required for contradicting the witnesses. Ms. B. Buyan, additional CP, prays for time to go to make submissions with regard to whether non-exhibition of the document would be fatal to the prosecution's case. This is the matter on Monday.
24/7.
Hello, with regard to item number 16, item number 16, my lord, I'm
Yes.
appearing there also. I'm not feeling well today, my lord.
Okay. On the
Any-
prayer for adjournment made on behalf of made by Mr. B. Prasad, learned amicus curiae, who submit that he is not feeling well, this is the matter. After review. Item 16. And we have got next. Okay. Okay, right. Ms. B. Buyan, additional PP submits. No, praise that the matter may be adjourned, as she doesn't have a copy of the paper book. A copy of the paper book has been supplied to her today. Full stop. This is the matter after review.
Lordship.
Much obliged.
We have to do some matter, otherwise,
15 already, your lordship, other side is.
but the other side, they're coming.
We didn't see them.
I hope they're coming, otherwise there's nothing for us to do.
Hmm.
Otherwise, maybe we can do this matter also. Slowly, slowly. In your matter, there's a dying declaration.
Dying declaration, but the main person, the mother-in-law and the husband has already died. Here only the brother-in-law is here.
Oh, that's what. You wait, don't go. Just in case there is no one to do the other matter, let us do something at least.
Yes.
I think we can do it together. Slowly, slowly. And if we cannot do it, if you're not satisfied, we'll give you time. But at least we will, on the next date we can complete. There's no one.
This case I have prepared.
You have prepared.
This case I have prepared.
No. So we are ready. That is not an issue. But if the other side is not there, what to do? So what we'll do is, let us start with his work,
Why not?
with his case. If we cannot complete, if you, after hearing you and, going through that, we'll all read it together. If you're not satisfied with the time that you have, we'll give you some more time, but at least let
But I
us
don't
start.
have today, I'm unarmed, my lord.
Anam,
Citation. I don't know
no,
what point
madam,
you take.
your diary is there or not?
My diary, my bag is also there.
Then-
Yeah, I'll leave it to your lordship.
Yes, so you have got your entire arsenal there. Yes, that. Item 15? You keep it for the timing, don't adjourn. Item 14.
So here the FIR is at page 1.
Just a minute, let us get the document. Page 1 is the FIR.
Page 1 is the FIR lodged by the mother of the deceased.
Mother of the deceased. And she's PW?
PW. PW2.
PW2. Okay, let us see. Page 1, let us start.
Yes. With due respect, I beg to state that 8 years ago, my daughter, Pinky De, got married to accused number 1 with proper Hindu rites and rituals. After the first marriage, the above named persons, on demand of dowry, physically and mentally harassed my daughter. Once my daughter had filed a case against the above named persons before the learned court below, but later, after amicable settlement, the above named persons brought back by my daughter to their house. Thereafter also the above named persons continued to torture and harass my daughter. On the day and time of incident, the above named persons forcefully administered poison to my daughter. Thereafter, my daughter, in order to save her life, came to my residence, it is Narsingpur, situated at number 1 Khanda, and soon we took our daughter to Silchar Medical College and Hospital for her treatment. Later, my daughter died. Therefore, sir, I request you kindly look into the matter and investigate the same. The contents of the FIR was read over to me and acknowledged put signature on the.
Okay, who is this accused number 1?
Accused number 1 is the husband
Husband.
who died.
Number 2 is the
Number 2 is the mother-in-law.
Ratan De.
Ratan De is the brother-in-law,
The elder brother or younger brother?
younger brother.
Younger brother. Younger brother of accused number one. And Pushpa Rani Day is the mother-in-law.
Mother-in-law.
Now, where were they living?
They used to live separately,
In the same,
same
same place?
compound, but separately.
No, no, what I'm saying is, this informant, Dipali Datta,
Yes.
said that on the day of the incident, the above named persons forcefully administered poison to my daughter. Thereafter, my daughter, in order to save her life, came to my residence, that is Narasinghpur. She came to Narasinghpur from where?
From Palanghat.
Langhat. How far is that?
It's around 3 kilometers, 3-4
3
kilometers.
kilometers. Then,
Then investigation was carried out and charge sheet was filed. Initially, the name of mother-in-law and the brother-in-law was not there in the charge sheet. But by the order of the court, they were arraigned as an accused and trial was commenced against them also.
in the charge sheet, they were
No.
not there. Where is the order of the court?
The judgment your lordship will find at page 78.
Yes.
If I may read.
Yeah.
On 6/5/2010, informant Srimati Dipali Datta.
No, no, where is that order by which the other two were charge sheeted?
But there is no separate order, but in the judgment itself,
No, there has to be.
there has to be, yes.
It has to be because the
There has
charges
to
have
be.
to be framed.
Yes.
against them.
Charge is there. Page 7, not sent up for trial.
No, not sent up for trial. But then.
After the added
after they were arrested, where is that order?
order is recorded. File for record.
That court records there?
And
Okay, look at.
The trial court order sheet is not available with me.
Okay, it is, okay. Then what happened? So there were charges were framed under which section? 302?
302.
Only 302. Then,
Then on the basis of, I would say, assumption, we are held guilty.
how many witnesses?
My lord, there are as many as 4, 5, 13 witnesses.
13 witnesses. Now, let us go one by one to the witness.
Yes. PW1, Office
Page-
of the Doctor, page 19. Is the uncle of the deceased.
Uncle of deceased.
If I
Yes.
may read, madam.
Yes,
I know the deceased Pinky De. She was my niece. Accused Raju Bhushan De is the husband of deceased Pinky De. Pinky De died about 3 years ago. House of father of Pinky De and my house are situated in separate compound. When my niece came to the house of her father, she reported that her husband tortured her physically and mentally. Once the accused person assaulted her and she sustained fracture injury on her leg, and she was admitted in Silchar Medical College and Hospital. The was assaulted because marriage articles were not sufficient. On receipt of information from SMCH, we went to SMCH and were in the SMCH for the whole day. But till the evening, we did not find any person from the house of the accused. On the following day, we again went to SMCH. Magistrate came and held inquest about the dead body of Pinky De and prepared inquest report. I put my signature on the inquest report. Exhibit 1 is the inquest report. Exhibit 1(1) is my signature. Parents of Pinky also reported me about the torture. I gave my statement before the police. Cross. In my knowledge, my house comes under Sonai PS. It is not a fact that my house is situated under Dholai PS. It is also not a fact that my house is at Kabuganj. It is not a fact that I stated before the police that this is Pinky De My niece yesterday, that is 6/5/10, consumed poison-like substance, and as a result, people of her husband house brought her to SMCH. Then approximately it was 1:30, but she died at 2. I cannot remember how many days the victim was in the hospital and when her leg was broken by her husband. She was treated at SMCH. I do not know how to read and write. I know somehow how to put my signature. When I put my signature exhibit 1 and on exhibit 1, I did not read the contents of exhibit 1. I have only heard about the torture of my niece by her husband accused Raju Bhushan De. It is not the fact that I have heard about torture on my aforesaid niece by the accused are all false. It is not the fact that I have stated to IO that we two brothers stayed whole night to look after the deceased. So here only the husband name is saying.
No, and out here there's nothing regarding consumption of poison.
No, nothing.
So this is out here nothing regarding poison. Then
In the next page, the further cross examination of PW1 Appeal Chandra Dutta.
how does this matter? If this is not relevant to the facts in issues.
Yes,
The fact is basically your case is that she died because of poison.
poison.
Now PW1 doesn't talk about poison. So that's not relevant. Let's go to PW2.
PW2, madam.
Yes.
Page 23.
Yes.
Oh no, I have filed this case about 3 years ago. I know the accused. He is present in the dock today. This is Pinky Day was my daughter. She was married with the accused 8 years prior to her death. Her marriage was solemnized socially. After marriage, she came to my house. I asked her as to how she was in her husband's house. She replied that she was not happy. She reported to me that as the marriage articles were not sufficient, the accused persons physically and mentally tortured her on demand of dowry. I did not give money to the accused persons. After marriage, my daughter gave birth to 2 children. In the year 2006, she came to our house with 1 child on being assaulted and driven out by her husband. Thereafter, a criminal case was filed. Thereafter, a maintenance case was also filed against the accused. Thereafter, on the assurance of the accused Raju Bhushan De that he would never torture the deceased.
Anyway, out here, basically, it says that at the time the deceased came by auto to my house and reported to me that her husband, mother-in-law, and brother-in-law administered poison to her.
Yes.
And to save her life, she came to our house.
Yes,
My husband told me to go to hospital.
this is slightly contrary statement what she has stated before the police, 161.
This is the mother, not father.
Mother. Yes.
Maybe 306 and maybe 213.
Attachment of suicide. Attachment of suicide. Oh, this is poison.
300. 302. 302. That's
What was that? Right, what is it? Yep. 9/1/15. 9/1/15. 30234. Yes,
So this is the first time in the deposition, the mother has come up and say that the husband, mother-in-law, and the brother-in-law administered poison on the deceased, and due to which she died. But in the 161 statement, if I may take your lordship to the 161 statement of Dipali Dotto, that is the
Yes.
mother, available at page 5.
page 5.
Page 5, madam.
Yes,
She has stated something else. If I may start, my name and address has been stated herein above. My statement is that my daughter, late Pinky De, was married to the accused Raju
let's
Bhushan.
go to the relevant portion.
Relevant
the
portion,
bottom.
my lord, your lordship will find, having failed to bear the torture
Hmm.
caused by the accused Raju Bhushan De, my deceased daughter had filed the case. Thereafter, the accused Raju De compromised with my daughter and took her back with him. In order to take revenge, the accused Raju Bhushan De forcefully
So
administered
Raju,
poison to
only,
my
only
daughter.
the husband.
Only the husband.
Now, but then, in the evidence, was she confronted with this?
Yes.
Page 23.
Page 23. Cross is available page 26.
Why is 24 something else? Acha. This is a
24
type copy.
type copy.
26.
My daughter Pinky Dotto got married 7 years, so and so years back prior to her death. She gave birth.
No,
of-
go to the report. This is going to take forever.
It is not a fact that page 27.
Ah.
It is not a fact that I did not state before police that my victim daughter reported me that the accused Raju and others
Okay.
forcefully administered poison to her.
Okay, confronted.
Yes.
Then let us go to the IO. IO's evidence.
IO's evidence is available at page 59.
PW.
Is examined as PW 13.
IO.
IO.
Where is the confrontation? I mean with regard to the statement of
Page 60. Page 61. PW 10 did not state before me that Kalpan Datta accompanied Pinky De, her mother, to hospital. Did not state before me that Pinky De told her that her mother-in-law, brother-in-law, and husband administered her poison.
no, but this is
But
this is PW2.
Yes, PW2.
PW2 is different.
Page 60, PW2 Dipali Datta did not state. Last
Page 60.
page 60. PW2 Dipali Datta did not state before me that she, along with her son Kalpan Datta, took the deceased.
No, this has not been brought to the notice of the IO.
It was in the inquest report, this page 63. Ravindra Kumar Singh, the further cross, page 63.
For the cross of whom?
Well, same person.
Of 13.
Yes,
Okay. Page 63. Yes.
63 and the fourth paragraph from last. PW2 did not mention before me about the names of any other accused person involving them except accused Raju.
Okay. Page 63.
Then page 64, the last part.
It is also mentioned here 63 in the middle also. It
Ye-
is seen that PW2 Dipali Datta did not state
Before
the
me.
deceased report to her
Yes,
that accused persons or any of the accused persons administered.
page 64 also in the last part. This witness did not state before me that on query, his daughter told him that her husband tortured
No,
her.
no, this is different.
Yes,
This is with regard to the father.
the,
PW2 is the mother.
yes,
So it should be this witness did not state before me that on query her daughter told. So this is with regard to some other.
but the following paragraph is important. The
Yeah.
witness stated before me that rest accused Ratan and Pushpa Rani were not involved.
No,
because-
but this is with regard to the evidence of the father of the
Yes.
deceased.
Father
So that-
also lots of contradictions.
So we'll see. So anyway, the contradiction with regard to the mother is proved regarding the fact that it was only the husband who administered the poison. Correct?
Mm.
Okay, then
Then
who else? Then father,
father 29 page,
PW,
PW3.
PW3. Father of deceased.
Yes,
So let page 29.
9.
Yes.
Informant Dipali Datta is my wife. I know the accused person. He is the husband of my deceased daughter. Deceased Pinky Datta is my daughter. She died about 3 years ago. On the day of occurrence at about 11 a.m., I was at home. Then I heard shouting and came out from the house. My wife and son also came out. I saw my deceased daughter came out from an auto rickshaw. She reported to me that her husband, mother-in-law, and brother-in-law forcefully administered poison to her, and she asked me to save her life. This is all full of contradictions. I will take your lordship to that. So I asked my wife and son, Kalpan Datta, to take the deceased to Narsinghpur hospital. After some time, I also went there, but did not find them there. Then I, along with my elder brother, went to SMCH and found my daughter lying dead. Before that, my daughter left behind 2 sons. About 8 years prior to her death, she
Before
was,
that, left behind 2 sons. After that, how many did she leave behind?
yes. On being asked, she reported to me that her husband physically and mentally tortured her on demand of dowry. On the day after being assaulted by her husband, my daughter was driven out from the house of the accused with her one child, and she took shelter in my house.
One day after being okay.
Then she filed a case against the accused person. Thereafter, the accused requested my wife to forgive him. So these are not that relevant. In the cross part, in the Hajira, which I have submitted before the court, I put my thumb impression. The said Hajira is exhibited at exhibit 8, dated so and so. It is not the fact that I have not stated to the IO that on last 6/5/10 in the evening when I had come to my house, heard that in the morning my deceased daughter took poison after quarreling with her husband, and she alone came from Palangat by an auto and went to Narsinghpur hospital with my wife Dipali Datta.
My deceased is and my deceased daughter took poison.
Yes. He was not present at the time when the daughter allegedly came to their house, because in his 161 statement, he clearly stated that after he came from his office, he came to know. It is not the fact that my deceased daughter was a hot-headed woman. In fact, she was a very cool-headed girl. It is not the fact that my deceased daughter often used to quarrel with the accused. My daughter filed case against the accused person. I do not know what she stated in the evidence in that case. It is not the fact that the deceased did not state to me that her husband, mother-in-law, and brother-in-law administered poison to her forcefully. If I may take your lordship to the 161 statement
Yeah.
of Kokil Chandra Datta. Page 15.
1-5.
Yes, my lord. The last part, relevant part is 5 lines from bottom. 5th line.
Yes.
The husband Raju Bhushan De is responsible for the death of my daughter. I do not blame the other 2 accused persons, Ratan De and Pushparani De, for the incident, since they live in a completely separate house and my daughter Pinky De and her husband Raju De used to reside in a separate house. As per me, Raju De is responsible for the death of his wife. It is full of contradiction.
No, just tell us now, who has died?
Mother-in-law and the husband,
So only the brother-in-law.
only the brother-in-law.
Brother-in-law is in jail.
No,
He's in bail.
bail.
Then who else? Now, so 3 we have heard. Then 4. Who is 4?
4 is
Relevant. Hearsay evidence or what?
hearsay evidence is
Page
page 33.
PW4. Huh? What's this?
I knew that this is page 33.
Yes.
I knew that this is Pinky De. I also know accused Raju Bhushan De. He is the husband of Pinky De. They are my neighbors. I had a good relation with them. The accused and the deceased used to reside in a house and
Okay,
other.
so hostile witness.
Yes.
So out here, he has not said anything against the
No.
thing. And what about PW5,
PW5 is the doctor, page 36.
page 36, doctor?
Yes.
So,
Doctor's evidence and page 37.
page 37, yes. So he sent to FSL.
Yes.
Now, what does the FSL report say? Poison?
Positive test.
Some poisonous substance.
Page? FSL report?
FSL report
37. No,
76.
Huh? 76. 76. Okay, insecticide.
Yes.
Organophosphorus. Insecticide. So is this organo insecticide, phosphorus insecticide, is it a poisonous substance or not?
I checked.
What is the evidence of this person who gave the toxicology report?
Evidence
What does he say?
only this page 36.
No, FSL report, who has given?
The senior scientific officer.
Was his evidence taken?
No, my lord.
Okay, anyway, that is leaving that aside. Okay, next, PW6. Who is it?
PW6 became hostile, 7 also hostile, 8 also hostile.
6, 7, 8 hostile.
Yes. But they all of them talked about the separate house. They used to reside in a separate house.
Who's But so anyway, they have not talked about the poison.
Yes.
So they are saying that the deceased and her husband lived separate.
Separately, and used to quarrel for some petty issues.
Deceased and husband lived separately. Okay, then who is 9?
Kalpan Datta, the brother of the deceased. Page 48,
Page 48, PW 9.
PW9.
Brother of deceased.
Yes.
What is his evidence?
He told this, the last part,
Page 49,
page 48.
48.
1, 2, 3, 4, 5, 6. Sixth line from bottom.
Yes.
Then
Okay, husband, brother-in-law.
Yes.
Again, same thing. What about his 161?
161 is full of contradictions. Kalpan Datta.
Page
16.
60.
16 million.
16.
Yes.
Yes.
The fourth line from bottom. Therefore, I suspect that accused Raju Bhushan they forcefully administered poison to her. Accused Ratan and Pushparni they are not
Not
involved
involved.
at all, as they completely reside in a separate
Okay.
house.
And then what about Ayo?
IO. I read the statement of IO. This
No, with regard to the wife, with regard to the mother and father, we have seen. With regard to the statement of PW9.
PW9. This PW13, page 59.
59 is the start.
Yes, page 61.
61. Yes,
61.
yes.
PW9 Shri Kalpan Datta did not state before me that on hearing cry of my deceased sister neighbors and Ruli, they came at the spot. This witness also did not state to me that the deceased told them that.
Yes, okay, okay. So contradiction proof. Then
One, there
we go to PW10.
Ruli there. It is the neighbor of the deceased.
So he's got nothing to say.
No, brother.
Neighbor of deceased, nothing.
She stated something but full of contradictions. 161.
What is she saying basically?
She said that when the deceased came to home crying, she confronted her, and the deceased told her that the husband, mother-in-law, and brother-in-law administered poison on her,
There is-
which is full of contradiction. Page 51.
Yes.
Fifth line from the above.
Hmm.
I saw an auto on the road and someone is crying, saying Ma. Then I went near the auto and saw inside the auto Pinky there.
Page 51.
51.
I
Saw an auto on the road and someone is crying, saying Ma. Then I went near the auto and saw inside the auto Pinky there, and she reported to me that her mother-in-law, husband, and brother-in-law administered her poison. Hearing her crying, her mother.
Okay, she's neighbor of deceased parents actually.
Yes. So it is full of contradiction. Page 14, if I may take your lordship, the 161 statement, page 14. He said clearly, fifth line from bottom, page 14.
Yes,
Therefore, Raju Bhushan is responsible for her
okay,
death.
same.
The other accused persons,
What about Ayo?
IO, page 53. Page 59. PW10 did not state before me, page 61. We have, third paragraph from bottom. PW10 did not state before me that Kalpan Datta accompanied Pinky Day and her mother to hospital. PW10 did not state before me that Pinky Day told her that her mother-in-law, brother-in-law, husband administered her poison.
Okay, then PW11,
PW11 is the auto driver,
page
page 54.
54, PW11. Auto driver, anything to say?
Contradictions, my lord.
Anyway, let us go to 54.
If I may read, my lord.
What's that?
Perfect.
Yes.
So hostile, so nothing. Correct, that's PW12.
56, my lord. So
Is the IO over?
later on, my lord, when the IO changed, my lord, on the date of occurrence,
Page 56, PW12, IO.
yes,
So it's then he's nothing much. PW13 is the second IO.
second IO.
No, 13 is the first.
No.
Whoever is
12,
only submitted charge sheet.
He submitted the charge sheet.
He
PW,
submitted,
PW12,
okay. So he's also the IO.
yes,
So both IOs, 13 and 12, 12 and 13 are IOs.
yes.
Then PW14,
Only 13, my lord.
13. Okay, doctor is PW,
5.
okay, so there is no proof of the brother-in-law and the mother-in-law having administered the poison.
Lordship, may I submit one thing? I have also checked the 161 statement. Specifically, there is no allegation against, and honestly submitting before this court
Wait.
against this fellow. But regarding the other two persons, I am not aware of whether
What
they
other
were
two
in the custody, Lordship, who expired. Whether they are in custody or they were in bail.
No, he said that they have expired.
They have expired, so I need to take a report from the jail authorities regarding whether the present position.
No, they have already been released during pandemic. And after the release of the mother-in-law, she died last year. And the
Let him
husband
produce
died.
the death certificate.
Death certificate, I have death certificate.
Let him produce on record.
Let's see. We'll take it up at 2. You bring the certificate.
Yes, my lord. Can
Okay.
expect 2.
Let him be produced on record, your lordship, of filing one affidavit or so.
Let us first see.
Yes,
Okay, because whatever it is,
Yeah.
basically, mother has to be set free anyway. I mean, mother-in-law.
no, mother-in-law and husband specifically named,
No,
but, oh, yes, I'm sorry,
only
husband was
only
there,
husband.
yes,
Only husband.
yes.
So husband, so we will still, that we will not touch. But brother-in-law and mother-in-law have got no case. There is no case against mother-in-law and brother-in-law.
Lordship, for the end of justice, I want to take just one day time,
No,
one
that
day.
we-
At the face of it, I did not find
No,
it,
no.
but it's a serious matter of poisoning, your lordship.
No.
All the matters which come before this honorable, before this bench is serious on the treasurer to, a treasurer for
No, you
me.
see, no, it's not that.
Yes,
See, the thing is that these witnesses, all of them, they have said that in their evidence, they have stated that mother, brother-in-law, and husband. But in the 161 statement, and which has been proven to be, wrong, they have only mentioned the husband.
to
So,
your lordship. But
what
lordship,
is-
since I have hurriedly gone through just one day
No,
time,
we'll give you one
yes,
day time.
one day time,
No,
only
we'll give
Saturday,
you one day
Sunday.
time, but we'll
Yes.
take it up again at lunch.
Yes,
We'll take it up again at lunch,
my lord.
because you cannot change the fact.
Yes,
These are facts, it's not
Yes.
a question of law.
yes, my,
So on facts, whatever we see, will dictate maybe not the final judgment, but the facts will dictate. Because the facts cannot be changed. So at the end of the day, the husband is a different issue. But the,
He says mid submission, the husband is also expired.
so that is a different thing.
Yes,
If he is expired, well, he's expired. But if he is not expired, then of course he'll have to go to jail. That's a different thing. So whether
Regarding
he's
the
dead or
brother-in-law
not,
and
that's a
mother-in-law.
different thing.
yes.
So, but then the mother-in-law, whether she has expired or not expired, or the brother-in-law, whether he's expired or not expired, they have to be acquitted. That's all. we're
Yes,
saying.
your lordship may pass that order.
Well, this
Maybe
is-
please to pass it out on Monday. Because hurriedly I have gone to, I have at the face of it, I did not find it, but since I've gone like within half an hour, it may not be possible. sir.
Same here, we're doing the same thing. We'll take it up at 2.
Fine.
again.
So that 2-1 more matter is fixed at court number 3. If,
No, you have to, you cannot do everything according to your whim. You tell
Well, one
them,
more thing, page 94, it is there, the husband, the conviction is ordered is only against the brother-in-law and the mother-in-law. Page 94,
94.
yes. In the result, I find that both the accused persons, Srimati Pushparani, that is the mother-in-law, and Sri Ratan, they are found guilty. The husband, because during pregnancy, he died.
Oh, husband is one. Oh. Then what do you mean? If there is no conviction against the husband, where has it stated that the husband died? There has to be something.
That's my. Paragraph.
Therefore, ha, ha, ha. During pendency of the case, accused Raju Sarcha aspirants, hence case against him or the people.
So these two persons, lordship, may I pray on Monday? Because I just want to have a look. I have gone through it, the face of it, I did not find 161 statement. Original I have checked, but I may miss something, so just one day, because the
But
state is
we'll-
issued.
okay. Nothing there. Huh? Huh? But,
Lordship may pass appropriate order, I leave it to your lordship.
because there's nothing here.
Yes, 161, father and mother has also says,
161, they have all said this.
yes, they used to live
They have
separately,
been
mother-in-law
contradicted in
and
their
brother-in-law.
evidence, in their cross-examination, they've been contradicted. IO also has supported that contradiction. Now,
Main culprit had expired, main person.
yeah, Green Corporate has expired. So there's nothing.
My lord, my lord. Detention illegal, it would be illegal detention if your lordship finds it, yes.
So, okay, right. Heard, Mr.
As this was.
S. Biswas, learned counsel for the appellant. As well as Ms. B. Buyan, additional PP. Hearing concluded, judgment reserved.
Much obliged.
Since you are not free.
Much obliged.
So, it's the end of.
We have got item 15 also.
Other than it's not there, your lordship.
They might come at 2 o'clock. Let us we'll just once.
Yes,
We'll
madam,
just
I'm
try.
prepared. I am ready with the
In
case.
case that they come and then they find that no court, then they will grumble.
My lord.
Okay. That's it, ma'am.
Obliged.
কোনো ফটো তোলা নাই এখানে আমি তোলা নাই দাদা কিবা যাওয়ার মাথা খুলি এটা আমার প্রবলেম নাই না PW11.
PW11 is there to break only that part. Rest part is not so important. And the PW1 is also a bit important. PW1 is the informant.
Okay, let us go straight away to 302.
302
Let us go to FIR
FIR.
page.
The FIR is page 1 itself of the paper book. Lordship, may I read?
Yes,
Informant here is Amol Boro 1.
is the PW number
PW1. Informant is the PW1.
relationship with the disease?
No.
No relationship.
no relationship with the deceased. Humble submission is that around 6 p.m. today, that
Nephew, your lordship.
Nephew, nephew of deceased.
Yes. Kameshwar Boro and aunt, mother, Thangring Boro were in their house, the below name accused person.
Nephew of deceased.
Yes.
Yes.
Lordship. Today on 17/10/17, while my uncle, husband of mother's elder sister, Kameshwar Boro, and aunt mother's elder sister, Thangring Boro, were in their house, the below name accused person trespassed into their premises and dealt cut blows on them with the dao in his hand with the intention to kill them and cause grievous injury to them. Immediately, my uncle and aunt were admitted at Lakhipur PHC, but as the injuries were serious, the doctor referred them to Gwalpara Civil Hospital for better treatment. At present, both the injured persons are undergoing treatment at Gwalpara Civil Hospital. I therefore pray to you to take necessary steps in investigation. So at that time they were injured. Later on, that wife, lady was expired, and the husband remained, and he is examined as PW11.
So both of them were alive at the time FIR was submitted.
That time. Afterwards, the lady died.
Died when? Wife died, lady died when?
Lady died in the hospital. Date PM report. On 18th, probably.
On
18th,
18th.
10 probably, because PM, I am reading from PM. Arrival in the 18th, on 18th, she was taken.
But when did she die? Any dying declaration? No.
No time later.
Okay.
So, this
She died 20 hours prior to the date of examination. 1810 examination was
1810 which, what time? What time?
2017.
date of
1810 2017.
Oh.
And a doctor says, which
No, what
that
time did, was she
time
examined?
since death about 20 hours.
When was she examined?
1810.
Time, date, time.
Oh, lordship.
One-
1810, 1:50 PM.
1:50 PM.
1:15 PM. That means on 17th then she died.
And date of incident was 1710 itself.
Just a minute. So postmortem report done on 1810,
1810,
17 at 1 PM,
1:50 PM.
1:50.
1:15 PM. And time of death,
20
time
hours.
of death,
20 hours prior to that.
20 hours earlier.
Lordship.
Okay.
And Ellie's incident as per FIR is at 6 or 6:30 evening.
Incident occurred on
6 or 6:30 PM
6
on
to
1710
6:30 at 1710.
2017. So
So it doesn't,
Lordship doesn't tally.
12, 13, 19 hours, nearly the same, 19 hours. Okay, anyway, doesn't matter, it died
In and
17.
around.
But what time was the FIR lodged? What time,
FIR
timing?
information received on 7:30 PM.
7:30.
7:30 PM. Okay.
7:30 on the same day.
6 PM is the date of incident.
Okay,
So now, may I read PW1
yes,
informant in 161
Yes,
statement, what he has
yes.
stated.
yes,
So that PW1 has stated, on the day of occurrence at about 6 PM, while I was in my house, the accused went there and wanted to cut me. Then I ran away from our house. Thereafter, the local people informed police. Police came and caught the accused in our house. That means appellant was admittedly arrested from the house of the informant. That is one aspect. Under
PW1 is the informant.
informant, he says from their house, he was arrested.
Okay,
One. Now, coming below, thereafter on hearing hue and cry in the house of Kameshwar Boro, that is the injured witness PW11, I went there and saw Kameshwar Boro and his wife injured condition. On query, Kameshwar Boro disclosed to me that he and his wife had been cut by the accused. This is also important. This is a direct disclosure on part of the appellant to this injured witness. However, to that effect, this was not in the 161 statement of this PW1 and which has been corroborated by the IO itself. So this has a little bit less evidentiary value, though it is in the for the first time in the court as PW1, neither in the 161 and IO has corroborated it. This was not stated before him. So this sentence is otherwise incriminating against him. However, not in 161. Thereafter, both the injured had been taken to Lakhipur PHC, wherefrom they were shifted to Gwalpara Civil Hospital on being referred. But the wife of Kameshwar succumbed to her injuries at Gwalpara Civil Hospital. I filed the Ejahar Exhibit 1, so and so. Then in last paragraph, police came and recorded my statement. Dead body of Thangring Boro, that is the deceased, wife of the Kameshwar Boro, had been taken away by police for post-mortem examination, and after post-mortem examination, the dead body was handed over to us, and accordingly, we cremated the same as per our rituals. So this much is the examination in SIF. So in the examination in SIF, the murder offense weapon was a dao, but in front of this witness, that dao has not been seized. 1 point again to be.
Anyway,
because that was against-
is so important when there is an eyewitness.
Lordship, that is just I am pointing out.
No.
Not so important, but otherwise thou has been recovered again from another place.
Okay.
And none of the witnesses stated that it was recovered from me. None of the witnesses stated.
Doesn't matter.
Anyway,
Your back is to the wall in this case.
Lordship. Now I will read the cross-examination part
Yes.
to point out that sentence.
Uh,
Incriminating one.
yes.
I did not see the occurrence of assaulting Kameshwar Boro and his wife by the accused. It is not a fact that I did not state before the police that on hearing hue and cry in the house of Kameshwar Boro, I went there and saw Kameshwar Boro and his wife injured condition, and on query, Kameshwar Boro disclosed to me that he and his wife had been cut by the accused. Now this part has been suggested. Later on, IO has confirmed it that it was not stated before IO. So it was suggested. To that extent, this PW1 has only stated.
No, so actually there is no contradiction as such. The only thing was that
Yes,
it was
omission.
not stated. It is an additional thing which he has stated in his evidence.
Evidence.
It is not a
Not
contradiction.
contradiction. It was not spoken by him to the IO.
Yes,
at the
it was not
point of time.
stated. So
It is
this
maybe a
this
omission.
aspect has only a
Sometimes
addition.
omission becomes contradiction if it has a very important role. Otherwise, because it has a very incriminating part. Now, this part, omission of this part will amount to contradiction only.
Where is the law which says that? Is there a law which says that omission will amount to a contradiction?
Contradiction, if it is Lordship, for that, I will refer sometime. I am not with that law right now, but I will be, I can provide it. When contradiction amounts to omission and amounts to contradiction, there is a law. So
Okay.
this incriminating part, however, was not told to 161. That much is the PW1 deposition. Now, Lordship, rest of the witnesses are not so important. To save the time, I can directly go to the
Yes,
injured witness
yes.
part.
If they are not
So-
important, no point.
Not eyewitness, admittedly.
Yes.
If time permits, I will read the entire. But now, may I go to the injured witness directly? It's
Page.
page PW 11 is 23.
Yes.
PW3 is Kameshwar Boro. What he said, I know the informant who is nephew. I know the accused person who is from my village. The deceased Thangring Boro was my wife. About 1.5 years ago, the occurrence took place at about 6 p.m. in our house. I was making beerids at the time, and the accused Basiram Boro came to our house with a dao and attacked my wife. And when I intervened, he attacked me too and struck me on my neck, forearm, forehead. I fell down and lost my consciousness. My wife died due to assault. I was hospitalized police investigated the matter and recorded my statement. I do not know why the accused attacked us. This much is examination in seat. So it's very clear that he has seen. Now, what defense did in cross-examination is not so much was there, but they are taking just simple plea regarding eyesight. I may read. It was dark at the time and there was no light. The accused Basiram was wearing a shirt. On the south of my house is the house of the accused, his neighbor. My son Rakesh Boro was not at home at the time. Other people did not see the incident. My wife was wearing a dokhana at that time. I did not see how my wife was cut. It is not a fact that the accused did not attack my wife and me on the day. My eyesight is weak and I do not see properly in the dark. So they are trying to just to bring on record that eyesight was poor and it was dark. So whether it was possible to identify the accused appellant or not. So to that effect, one important aspect is that though this plea has been tried to be taken, but in admitted position that time accused is preparing some biris.
Yeah.
So that means eyesight, even though it's not like that, like amount to blindness that one cannot see. So this is very important aspect that one person is working admittedly in the seat and that has not been elicited. So
Preparing BD, your lordship. Preparing BD, I don't think eyesight should be like,
No, you see, it was dark, meaning what outside dark was the, how was the,
yes, but he is from the same village.
no,
He's
no,
acquainted with
that
it.
is nothing.
Yes.
It was dark doesn't mean that you cannot
Yes, recognize
uh,
your neighbors.
like you see in the full moon, you don't say it is light, you say it's
Yes.
dark. That's neither here nor there.
but at the same time, another sentence is there.
Why should you see? Was there any enmity?
No, nothing.
Was so there's no,
Premeditation
then
is
why,
also-
then why should he
Enters
make an allegation against the appellant
and his neighbor admittedly.
and the neighbor?
Neighbor.
He knows his
He knows.
neighbor.
So that is the identity that to that whether you
You
are
see, even in the dark, actually your neighbor
a
you
neighbor
can take
comes.
out. In fact, from behind also some persons that you know well, even without seeing them, you can know them by the shape of their head, by the way they walk. If I see Kuntal or this Data also, in the dark, I'm quite sure I can make him out from the back there.
that is admittedly neighbor. But at the same time, one more sentence is there, Lordship. But he admitted in cross that I did not see how my wife was cut. So that also a doubtful statement. Because we are in the same house. If accused enters and cut my wife, and it is not so dark to see who have come. So this sentence is again-
You see, it's a very subjective question.
Lordship.
What was the question? How did you? No, when someone is attacking you, you don't keep. He's attacking you. He's attacking your wife. You don't keep note as if his hand was at a right angle, coming down at 90
Lordship.
degrees or something.
No,
You
that
are
cannot
only
be.
trying to protect and
Not
trying to
humanly
run
possible.
away and all. This is not a young man. He's
Yes.
old. He's
If-
70 plus. Come on.
And the lordship will see the nature of injury sustained.
Ah, yeah.
If lordship considers the evidence
Correct,
of PW.
correct. I saw
Multiple
the
injuries
doctor,
in
yes.
backside of the neck.
Deep cut
arm,
injury on the left and
Yes.
back side of the neck.
neck,
Cut injury on both forearms.
forearm.
Cut injury in forehead, skull.
This
Where is
is-
the time to really let me write down how, what angle? There's no-
It's repeated.
Even us, and he's a 70-year-old man. Old men, their reflexes are very slow.
Lord.
Oh.
So that is the only part. And apart from this, the defense has not been able to.
You see, if there was some motive, some enmity,
That is not there, admittedly. And
nothing
in
is
fact,
there.
in 313, he has not explained anything. 313 is like usual manner. He has not explained in a
Who is
single sentence.
who is PW 13? Ayo.
Below 13 IO. So apart from this, in defense, in their favor,
But why did this person attack? In
So-
the first place?
so
His conduct, my lord, Says he.
Because he
got
attacked
mentally
PW1 also.
Stable, but that
PW1
plea
is
has
for
not been taken.
He
So that
attacked
is the
PW
why,
one also.
without any motive, why he attacked PW1 informant? Until unless he is having some mental issue,
Mental, maybe.
psychiatric
Maybe
problem,
also.
can one,
If your lordship's desire, I may ask for a report from a jail authority.
For what?
But
Now, that is not of no use
is-
now.
they have not-
That is not the issue.
yes,
That is not the ground that they have taken also.
yes.
Why should we go into that?
And motive is not an integral
That
part.
thing is
When
there.
direct evidences are there, I have got judgments. Is it clear?
Anyway, that's your case.
that much only.
Yeah,
Only-
this
oh.
case to appeal conviction, I'll just record 2 judgments.
Yeah.
On
Okay,
injured eyewitness,
yes.
as well as in absence of motive, your lordship may still upheld the conviction. Regarding the motive part, 2010 7 SCC 496. Listen. Para
Para?
11, para 11.
And
In this regard, we wish to refer to a decision of this court in Raghubir Singh versus State of Punjab, para 13, your lordship.
yes,
The motives may be minor, but nonetheless, they did provide an occasion for attack of the deceased by the appellants. That apart, even in the absence of motive, the guilt of the culprits can be established in a given case if the other evidence on the record is trustworthy and the absence of proof of motive has never been considered as fatal to the prosecution case, but the ocular evidence is found reliable.
no, that is there even where there is no ocular evidence. Even in circumstantial
My lord,
evidence,
my lord,
sometimes it may not be required to discard the
Lordship.
prosecution case
my lord.
in the absence of motive.
My lord. And regarding my lord, injured eyewitness, may I refer 2015 11 SCC 476.
2015
11 SCC
for
476.
injured eyewitness.
Yes. Para 7, 8, and 10.
Yeah.
Para 7. It is clear from a reading of the examination chief as well as the cross-examination that short of PW3 not being able to tell the court as to how many injuries were received by the deceased and in what weapons, the factum of their being beaten up by the persons who were named is not shaken. It is obvious that in a night it is very difficult to make out who hit whom and with what. The learned additional session judge painstakingly went through the evidence of PW, all 14 witnesses, including the 2 injured eyewitnesses and a doctor, PW8, who testified that the deaths were homicidal in nature. PW7 and the investigating officer deposed as to the recovery of the weapons that were used in the incident. The investigating officer PW13 stated that according to the voluntary information of the accused, Ramavattar, 1 X was seized and still. Similarly, lathis were recovered from the others. From Badru Ram, which was recovered from water behind his house. From Shivlal from plants and bushes behind his house. And a Gandasi from the statement of accused Lakshman from a field where brinzes were planted. The same is with respect to the lathi recovered in the instance of accused Sitaram. The courts below have painstakingly gone through the evidence and have relied heavily upon the evidence of 2 injured eyewitnesses and the investigating officer together with the opinion of Dr. J.P. Bugalia, PW8. My lord.
There's nothing here. What is that?
No, regarding the injured eyewitness, my lord, whether your lordship will take into account.
What injured eyewitness?
My
What
lord.
does it say? What is the law laid down? You just talk about facts of the case.
My lord,
It
My
has
lord,
not
may I
laid down any law. It has only talking about the facts of the case here.
it's regarding the absence of motive part, my lord.
That
There are
was-
10.
that is already there here. in
Yes,
the first
and
case.
one more judgment eyewitnesses.
Yes.
2023, 5 SCC 39,
2023,
5 SCC 391.
yes,
Para 22, 23, 24, 25, 41, 44, and 46.
44,
44,
Fort-
22, 23, 24,
25.
25, 41, 44, 46,
41, 44,
and 46.
46, yes.
May I refer para 22 first?
Yes,
The general principle of appreciating the evidence of eyewitnesses is that when a case involves a large number of offenders, prudently it is necessary but not always for the court to seek corroboration from at least two more witnesses as a measure of caution. Be that as it may, the principle is quality over quantity of witnesses, affect omission deficiencies. The evidence of examined as a whole must reflect ring of truth. The court must not give undue importance to omissions and discrepancies which do not shake the foundation of the prosecution case. And para 24. If a witness is absolutely reliable, then conviction based thereupon cannot be said to be infirm in any manner. A witness being a close relative is not a ground enough to reject his testimony. Mechanical rejection of an even partisan or interested witness may lead to failure of justice. The principle of falsas in falsas in omnibus is not one of general application. Bhagwan so and so. Then your lordship, para 41. Merely because no recovery was made from anyone apart from the accused 2 and 4 would not mean that otherwise not present in the scene of the crime. Simply because a number of witnesses had turned hostile does not on its own give a ground to reject evidence. PW1 and that PW1 being the brother of the deceased and therefore is an interested as well as chance witness are untenable submission. It is in the backdrop that we do not find favor with the submission of Mr. Nagarmatu S. and that Dr. K. So and so learned senior counsel appearing for the appellants that the conviction of 8 persons based on solitary evidence is not justified, particularly when there is no vagueness in his testimony with respect to the role ascribed to each. It's regarding the case of 149, my lord. Then page para 140, para 44. A primary submission laid was that reliance on a solitary witness to convict as many as 8 people is excessive. On a specific query by the court as to what the learned counsel can point to impeach the veracity of PW1's testimony, the answer was to say that looking at a number of external factors as also the testimonies of other witnesses, the elements to demolish the credibility are present, which to our mind does not merit interference. For the heightened scrutiny requirement as observed by this court in Jagdish versus State of Haryana to be held as unjustified. The surrounding evidence would have to be called into credible question, which it was not. The admission made by PW7 in its examining chief have not been disputed and neither has, as already observed earlier, the presence of any of the accused been disputed. Keeping in view the principle noted in Minaldas, so and so can undoubtedly from the basis of conviction. We have also noticed the holding in a landmark Masalti where the learned counsels have held that prosecution need not prove specific. It's regarding 141(9) minor. Then 46 PW1 is an interested witness being the brother of the deceased. Also he being the solitary witness upon which he has not taken that plea. Husband is the witness. That lordship, the evidence of PW11 is sufficient to convict. He being the injured eyewitness. So lordship will uphold the conviction.
What about the recovery of the weapon?
So that is only one seizure list is there in page number seizure list. None of the witnesses stated that.
No. PW5 has stated 2 and
yes,
5 about the seizure.
Not stated, but it is not stated that it was seized from me. So that is very
PW?
important.
2 and 5. 2 is the Gaubura and PW5 is the nephew.
So these two
It is
witnesses what they
seizure
say.
witnesses.
Anyway, they have said that the weapon has been seized.
Only.
Yes.
not from me,
Whether not from you, not from appellant,
appellant.
but then how does it matter? When someone has seen, when the Supreme Court has said in so many cases that non-recovery of weapon is not fatal, when there are eyewitnesses to the crime, then,
So that is it.
and they have recovered it. Only one thing is that these weapons actually should be sent to FSLN, but they have not been sent.
They have not. They did not.
That is a different issue. Now, besides this,
Is- if- Lordship,
just we're still intrigued. Why did he attack?
My lord. So his
without any
mental
premeditation.
condition.
Huh?
No premeditation is there.
Nothing.
Alcoholic influence like this, intoxicated displeasure or.
Alcoholic, they won't.
It will not do until unless-
Alcohol, they have to
That
have a
is- that
fight
has to
first.
be
They have to have a fight.
Yesterday's matter, your lord.
Lordship,
But maybe there some drugs or something. I don't.
that can. And Lordship, whether it helps or not, page number 55,
55.
page number 55. I'm just pointing out.
Yes.
So it's a injured witness medical examination. Now what happens when a
There's a.
injured witness, that is PW 11's medical examination, because he was injured. So what happens generally when the victim of a this type of fight and all brought to the hospital, the doctor is to record the history. So now if we go by the history, the doctor has not recorded that this fellow, that this appellant has attacked. This is what I want to point out before your lordship. Short history of incident is simply, it is written, Ellie's assault on 17/10/17. Sometimes-
This old man will not be in a position to
Yes.
speak.
That is there. However, I just
70-year-old
pointed
man, his skull has been cut. What will he say?
But accompanying person is also not describing. Sometimes
Accompanying person is not an eyewitness.
that is also true, because he became unconscious. He took
He became unconscious.
after the incident. So
correct.
how can he?
Yes.
So that may not go.
And in fact, if the accompanying person gave a very long history, then you will say, how did he know this fellow was not there?
Lordship, that is true. So this will not go.
Difficult for you.
Difficult.
Here am I this.
Am I custom?
This is a this is a open and shut case it appears.
Lord,
Because they have
As
seen
it appears. Because it's a case of injured witness. He's
his
alive.
wife has died and he has been badly injured.
Not explained his circumstance in C13.
Ah,
He's not explaining nothing.
So, I mean, and then PW1, who is the informant,
He is
he
also
also was attacked by the same
attacked by
person.
the same person. So his conduct is also.
So, I mean, it's not that, this is something that has happened, I mean, only to one person. It has happened to three persons. Right, Mr.
P. Bhagavati.
B. Bhagawati, learned amicus curiae, and Ms. B. Bhuyan, additional PP. This appeal has been preferred against the judgment dated 3/3/2020, passed by the Court of the Session Judge, Golpara, in Sessions Case number 74/2018, by which the appellant has been convicted under section 302, has been convicted under section 447/324/307/302 IPC and sentenced to suffer simple imprisonment for 1 month under section 447 IPC. He has been sentenced to suffer simple imprisonment for 1 year under section 324 IPC. He has been further sentenced to suffer simple imprisonment for 10 years with a fine of rupees 3,000, in default simple imprisonment for 6 months under section 307 IPC. The appellant has been further sentenced to suffer imprisonment for life with a fine of rupees 7,000, in default to suffer simple imprisonment for 6 months under section 302 IPC. All the sentences are to run concurrently. The next paragraph. The prosecution case in brief is that an FIR dated 17/10/2017 was submitted by the informant / prosecution witness -1 bracket PW -1 right close to the effect that his uncle and aunt, his uncle bracket PW11 and aunt were attacked by the appellant with a dao. Bracket, you write, dao will be long knife, long knife.
Like
Long-
whichever one wooden handle or like sometimes.
No. How do we, in English, how it works?
That cannot be.
Now,
Dao would be a
Leo, my love.
long, heavy knife. Okay. Long, heavy knife. We just say, don't say long, heavy knife, we just say, a long, heavy blade with a short wooden handle. Long, heavy steel blade with a short wooden handle. Inverted commas. Causing grievous injuries to them. His uncle and aunt were admitted at Lakhipur Public Health Center, Primary Health Center, bracket PH. However, as their injuries were serious, the doctor referred them to Golpara Civil Hospital for better treatment. At present, both the injured persons were thereafter undergoing treatment at Golpara Civil Hospital. In pursuant to the FIR, Lakhipur PS case number 371/17 under section 447/326/307 IPC was registered. Soon after the registration of the criminal case, the wife of PW11 died due to the injuries sustained by her. Gustav. Next paragraph. After investigation was completed by the investigative officer, bracket IO, a charge sheet was submitted, wherein a prima facie case was found against the appellant under section 447/324/307/302 IPC. Charge was framed against the appellant under section 447/326/307/302 IPC, to which the appellant pleaded not guilty and claimed to be tried. Thereafter, "13 prosecution witnesses were examined by the learned trial court. And after examination of the appellant under section 313 CRPC, comma, the learned trial court came to a finding that the appellant was guilty of the offense under sections 447/324/307/302 IPC. He was accordingly convicted and sentence was passed as indicated in the foregoing paragraph. Foregoing paragraphs. What was the ground of challenge?
It is appeal.
Ah.
Since it's a jail appeal, appeal memo
Memo kon nai.
Lordship,
holding
memo
the memo.
appeal with grounds are not usually from jail one letter. It is
No. Right now, what was the challenge you made to the appeal? To the impugned judgment?
impugned
Here,
judgment.
what is the challenge here in this case?
So non-recovery of that thou
Not
these are-
recovery. No motive.
no motive. These
And
were taken.
Any other?
Any not so significant grounds were taken in the judgment
The learned
that
amicus,
it is a case for them. It is a case of no eyewitness because his eyesight was poor,
okay,
so he cannot be treated as DSON. So these are
Okay.
taken.
the learned amicus curiae submit that the evidence of PW 11, the injured with eyewitness shows that the incident occurred when it was dark. And as PW 11 had stated that he had poor eyesight, it could not have been possible for PW 11 to have identified the appellant as the assailant who had attacked him and his wife.
And another ground is that thou was admittedly seized from the house of one Devendra Boro. That
PW,
is PW1's father. He has not been examined.
okay,
He is PW1's father.
full stop. Further, though the appellant has been accused of attacking PW 11 and his wife with a dao, the dao was not recovered from the possession of the appellant, but was recovered from
The house of
the house of the father of PW1
informant.
(informant). He also submits that the father of PW1 was not made a witness in this case. He also submits that the prosecution has not been able to show the motive for the appellant to have committed the offense against PW 11 and his wife and his deceased wife. Full stop.
And one more is that appellant was not found in the PO.
At
Because
the-
the appellant was not arrested from the PO, but arrested from the PW1's house. That is also.
Full stop. Further, the appellant was not arrested from the house of the injured eyewitness, that is PW 11, but was arrested from the house of PW 1. He
and
according,
non sending of the DAO for FSL. DAO was not sent for FSL.
he also submits that the DAO was not sent to the FSL for examination. Accordingly, the prosecution could not have been said to prove the guilt of the appellant
Motive part is also taken.
beyond all reasonable doubt. Further, there being no motive being attributed to the appellant for allegedly attacking PW1 and his deceased wife, comma. The prosecution case that the appellant was the perpetrator of the crime has to be discarded. They accordingly praised that the impugned judgment passed by the learned trial court should be set aside and the appellant should be acquitted of the charges framed against. Full stop. Next para. Ms. B. Buyan, the additional PP, comma, on the other hand, submits that the the appellant has been identified by PW11, who is the injured eyewitness in the case. Full stop. She submits that the appellant was a neighbor of PW11 and even though no motive could be attributed for the attack on PW11 and his wife, comma. The absence of motive cannot be considered to be fatal to the prosecution case where the ocular evidence is found to be reliable. Full stop. Anything else?
Yes. As the accused belong to the same village, my lord, and the PW11 recognized him, even he had a poor eyesight.
Full stop. She submits that PW11 had recognized the appellant even with his poor eyesight, as they were not only neighbors, as they were neighbors in the same village. That's all. What else is there?
There's nothing to disbelieve him being the injured eyewitness. So credibility of this witness, lordship,
As such, full stop, as such, there is no reason to disbelieve the testimony of PW1
he being the injured eyewitness is very much present at the place of occurrence.
as he was the one who was attacked by the appellant. That's all. Full stop. He accordingly submits that there is no ground to interfere with the impugned judgment and the impugned judgment and the same should accordingly not be disturbed. We have heard the learned counsel for the parties. The evidence of PW1 is to the effect that on the date of the occurrence at about 6 p.m. while he was in his house, the appellant wanted to cut him, which necessitated PW1 to run away from his house. The local people informed the police, and the police came and caught the appellant from his house. On hearing a hue and cry from the house of PW1 11, he went there and saw PW11 and his wife in an injured condition. PW11 thereafter told him that he and his wife had been cut by the appellant. The injured were then taken to Lakipur PHC, from where they were shifted to the Golpara Civil Hospital. However, the wife of PW11 succumbed to her injuries at Golpara Civil Hospital. PW1 also states that he thereafter filed the FIR. The police thereafter recorded his statement. He also stated that PW1 also stated that the dead body of the wife of PW11 was taken away for post-mortem examination, and the dead body was handed over to them for cremation, for cremation. In his cross-examination, PW1, who is the nephew of PW11, stated that he did not see the assault made on PW11 and his wife. He also states that he also denies the suggestion that he did not tell the police that he also denies the suggestion that he did not go to the house of PW11 and did not see them in an injured condition. He also denied the suggestion that PW11 did not tell him that he and his wife had been cut by the accused. Next para. The evidence of PW2, P4, 5, 6, 5 to 8 are hearsay evidence, except to the extent that PW 2 and 5 have stated that they were seizure witnesses to the seizure of the dhow by the police. from the house of Debendra, Debendra, who is the father of PW1. It's either Debenboro and Debendra are same.
Uh,
How do you know?
PW1 says from my house in his
Okay.
deposition. From that, I thought ki Devendra must have been Devenboro.
He says only with regard to the, only with
That
regard.
third line he stated, I
Huh?
ran away. Thereafter, the local people informed police. People came and fought the house in our house like that. He was arrested from there.
But not the, but not
Regarding
the
Dow.
weapon. Weapon is
Dow.
from Devendra.
No,
Dow. Dow is
he's the son of Deven.
Huh? Correct,
Amol Boro.
correct, but two
But Dow.
says that
Dow is
the
from
Dow
Devendra.
was, she's from the house of Devendra.
Devendra.
Whether Devendra and
Whether
Deven.
Devendra and Devendra
That
was
cannot be said, but it can be said that not from the PU or not from my position. That has not come on evidence.
okay.
That is not come.
I will state it from the.
I will say from the
Caesar list also. from the-
You see, another thing is, you see, Deben Boro and Devendra may be same. And okay, father of Deben, but PW1 may be living in with his father.
But that has
Then-
not come. But has not come.
What do I say? Two to eight. Witness to the seizure of the Dow. Full stop, full stop. Next para, Full stop, next para. The evidence of PW9 is to the effect that he was posted at Golpara Civil Hospital. And posted as Golpara Civil Hospital as medical and health officer 1. Wherein he examined the dead body of the wife of PW11. He found multiple lacerated injuries all over the body of various sizes and also multiple bruises all over the body along with incised wound by sharp weapon on the back of neck, shoulder joints, both shoulder joints, both arms on left elbow and on left elbow. Pusta. In his opinion, the death of the wife of PW11 was due to severe shock and hemorrhage following multiple injuries all over the body, which were ante-mortem. And the time of death was about 20 hours. And the time of death, and the time since death was about 20 hours. The evidence of next paragraph, the evidence of PW10 is to the effect that he was the medical officer posted at Golpara Civil Hospital. And he conducted a medical examination upon PW11. He found deep cut injury over left side of his neck, and one over the right forearm, measuring 8 into 1 into 1 cm and 6 into 1 into 1 cm respectively. In his cross-examination, PW10 states that the injuries were caused by sharp weapon. Next, the evidence of PW 11, the injured eyewitness who at the time was 70 years of age is to the effect that the informant bracket PW1 was his nephew. Full stop. He also stated that he knew the appellant who was from his village. The deceased was his wife, and that about 1.5 years ago, 1.5 years ago, 1.5, I think it should be 1.5. 1.5 years ago, the incident occurred in his house at about 6 p.m. While making bidis, Mustafa, while making bidis, the appellant came to their house with a dao and attacked his wife, Mustafa. When he intervened, the appellant attacked him and struck him on his neck, forearm and forehead, Mustafa. He fell down and lost consciousness. PW 11 further stated that due to the assault, his wife died while he was hospitalized. Subpara. Call Nilake. Oh, in call Nilake is free, no? I think he's free. I think he's not got a new one. Call Nilake. Because this I'll give her tomorrow, and I have to divide the work, you know. But I need to work at night. In his cross-examination, PW 11 states that it was dark at that particular time and there was no light. The appellant was wearing a shirt. The house of the appellant was on the south side of his house. His son Rakesh Boro was not at home, and other people did not see the incident. He states that he did not see how his wife was cut. The PW 11 denied the suggestion that the appellant did not attack his wife and him on the said day. PW 11 also stated that his eyesight was weak and he could not see, that he cannot see properly in the dark. Next paragraph. The evidence of PW 12 is to the effect that he was working as a medical and health officer at Lakhipur BPHC on the particular day, on 17/10/2017, and that he conducted a medical examination of PW 11, who was around 70 years, at about 7:30 p.m. On examination, he found a deep cut injury on the left and back side of the neck, cut injury in both forearms, cut injury in the forehead, scalp and skull. Gustav. He found the patient was in a critical stage and was referred to Golpara Civil Hospital. The age of the injuries were 1 to 2 hours. He also exhibited his medical report as EXT5 and identified his signature as EXT5 bracket 1. How many witnesses? Okay, last one.
Only 13.
13.
We are doing so many PW 1, 2, 3, we start getting confused.
Yes.
And yesterday that 2 judgments were passed. Both were killed by the husband. Both husband killing the wife. And both were fire, bride burning, dowry
And
related.
one more matter which was adjourned, that was also dying declaration was there.
And sometimes if you keep these matters, you keep them for say half a day or 1 day, you get confused,
Yes, Madam.
because they are quite similar. Okay, where are we? Next. Where are we? Okay, right. The evidence of PW 13, who is the IO of the case, is to the effect that he had registered the Lakhipur PS case number 371/2017 on the basis of the FIR submitted by PW1. During investigation, he visited the place of occurrence and examined witnesses, besides preparing the sketch map. He seized the dao, he seized the weapon, bracket dao, from the possession of the appellant and arrested the appellant. He took steps for inquest and post-mortem examination of the dead body and also seized one sari. He also sent PW11 for treatment, and after collecting the inquest report and post-mortem report, he submitted his charge. He also stated that he did not send the seized weapon for any expert examination. And he did not collect any fingerprints. He also stated that PW1 did not state before him, did not tell him that he heard a hue and cry in the house of PW11, or that PW11 or that PW1 or that PW11 had disclosed to PW1 that he and his wife had been cut by the appellant. Next pass. In the examination of the appellant under section 313 CRPC, the appellant has given a blanket denial with regard to the evidence that has been adduced against him. The learned trial court has, on considering the evidence, Right. Come to a finding that the testimony of the injured witness PW11 was sufficiently reliable and trustworthy to come to a finding of guilt with regard to the injuries inflicted upon PW11 and the cause of death of the wife of PW11. Accordingly, the learned trial court had convicted the appellant under section 447/324/307/302 IPC. Next. Please. On considering the fact that where is the 161 statement of this PW1? 161 statement of PW1, where is it?
In judgment.
No, 161 statement, is it here in the paper book?
Or is it not there? Is it not in the paper?
Let us see. What does it say? Does it? He does not say. All right, on considering the statement of PW1 made under section 161 CRPC, we find that he has not made a mention with regard to PW11 stating that PW11 and his wife had been attacked by the appellant, though the same finds mention in his testimony given before the learned trial. The IO of the case,
PW13.
bracket PW13, has also confirmed the fact that PW1 did not
No.
make any statement to the effect that PW11 had disclosed to him that he and his wife had been cut by the appellant. That's not there. Though there is no contradiction as such in the statements, in the statement made under section 161 vis-a-vis his testimony before the learned trial court, we find that PW1 has, for the first time, come out with a new fact in his evidence, in which he had stated that PW11 had disclosed to him that he and his wife had been cut by the appellant.
Disclosing part is not there, but 161 statement said that the accused came and attacked. But
No, no.
disclosed by PW11 is
PW11,
not.
that's what I'm saying, only that part.
Right.
So accordingly, I mean, so he's been contradicted in a way.
Improvement, one kind of.
Huh?
It is called, that can be termed as improvement, embellishment.
As such, the evidence the evidence of PW1 with regard to the above statement can be said to be an improvement on his earlier statement made under section 161 CR. However, the no, let's have a full stop. Let's go. The above being said, comma, the fact remains that PW11, who is 70 years old, comma, has identified the appellant as the person who attacked him and his wife. Full stop. The appellant is a neighbor of PW11. Full stop. There is no evidence to show that there was any enmity between the appellant and PW11. There is also no motive there also appears to be no motive for the attack on PW11 and his wife by the appellant. As such, there does not appear to be any reason for PW11 to make his allegation to make any allegation against the appellant as the person who attacked him and his wife. Though a lack of motive would weigh heavily against the prosecution in a case of circumstantial evidence, comma, the facts of this case shows that the incident of assault has been seen by PW11. By, with what have I said? Comma, who is an injured eyewitness. PW11 has not only identified the appellant, but was also the recipient of the injuries inflicted upon him by the appellant, comma, besides the appellant having taken away the life of his wife. Full stop. In the case of Raghubir Singh versus State of Punjab, 1996, 9 SCC 233. Come on. The apex court has held that even in the absence of motive, comma, the guilt of the culprits can be established in a given case. Comma, if the other evidence on record is trustworthy and the absence of proof of motive has never been considered as fatal to the prosecution case where the ocular evidence is found reliable. Next paragraph. In this particular case, we do not find any reason to doubt the evidence of PW 11. Wherein he has identified the appellant as the assailant who had attacked him and his wife. And in the result had taken away the life of his wife. The evidence of PW 13 is to the effect that he sees the weapon of assault, bracket down, from the appellant. And there is no suggestion made by the appellant to PW 13 that the weapon was not seized from him. Puस्तक. That's all. What is the anything else to add? Nothing, you know. Anything else to add, madam? Anything else to add, Mr. Am I just?
Lordship, in my opinion, that is covered.
So, Lordship
That's
is
covered,
covered.
no?
Madam.
On considering in view of the reasons stated above, comma, we do not find any ground to interfere with the impugned judgment passed by the learned trial court. We are also of the view that the prosecution has been able to prove its case, prove the guilt of the accused, prove the guilt of the appellant beyond all reasonable doubt. The appeal is accordingly dismissed. Send back the LCR in view of the appreciation.